Welcome to the YouTube channel of Snelata Shrivastava, XSG Lok Sabha. In this video, I am going to tell you about the expulsion of a member of parliament. The term expulsion has not been defined in the constitutions, rules of procedure, and conduct of business in Lok Sabha or any law relating to elections. But there are judgments of both Punjab and Haryana High Court and Madhya Pradesh High Court, which clearly indicate the vacation of seat is an automatic result of expulsion. The purpose of expulsion is to get rid of the person who are unfit for its membership in the House. In a judgment delivered on 29th August 1966, the Madhya Pradesh High Court upheld the expulsion of Yeshwant Rao Meghawale and Pandhari Rao Kriduta from the membership of the Madhya Pradesh Legislative Assembly and observed that since the Legislative Assembly had the power and privilege of expelling a member, resulting in the vacation of his seat, the correctness, legality, or propriety of the two resolutions adopted by the Legislative Assembly on 17th March 1966, expelling the two members, as mentioned by me earlier, could not be challenged in court of law. This is the Madhya Pradesh case. However, in another judgment delivered on 18th April 1977, the Punjab and Haryana High Court, by a 3-2 majority, held that a state legislature is not clothed or do not have the power to expel duly elected members as a measure of punishment for contempt of the House. The judgment said the punishment for contempt of the House was known and well settled as being reprimand, suspension from the House for the duration of the session, fine, and lastly, the keystone in this context being the power to commit the contemptor to prison. The Punjab and Haryana court in Haridwari Lal case declared that the House says in India have no power of expulsion, and the Madhya Pradesh High Court in 1966 declared that the House has power of expulsion. These two conflicting decisions were finally resolved by the Supreme Court in 2007 through its decision on petitions filed by members expelled by the House in cash for query case. A 5-judge constitution bench of the Supreme Court of India, which took up the core issue of power of the Houses of Parliament to expel their members, pronounced their judgment in the matter on 10th January 2007. The Supreme Court, in their majority judgment comprising judgments given by the then Chief Justice of India, Y.K. Sabharwal, Justice K.G. Balakrishnan, and D.K. Jain, and a separate judgment given by Justice C.K. Thakkar, upheld the powers of the House to expel members, and that every legislative body possesses power to regulate its proceedings, power of self-protection, self-preservation, and maintenance of discipline, in exercise of which it can suspend or expel a member. It was further held that the contempt of authority of Parliament can be tried and punished nowhere except before Parliament, though the exercise of the legislature's contempt power is subject to judicial review. In his dissenting judgment, Justice R.V. Ravindran held that the Parliament did not have the power of expulsion. But in the Supreme Court, in their majority judgment, observed the power of expulsion can be claimed by Indian legislature as one of the privileges inherited from the House of Commons through Article 105 subpara 3 of the Constitution. Contempt of authority of Parliament can be tried and punished nowhere except before it. The judicial review of the manner of exercise of power of contempt or privilege does not mean the said jurisdiction is being given to the judiciary. As has been noticed in the context of Article 122(1), mere irregularity of the procedure cannot be a ground of challenge to the proceedings in Parliament or effect thereof. And while the same view can be adopted as to the element of irrationality, but in our constitutional scheme, illegality or unconstitutionality will not save the parliamentary proceedings. The Supreme Court, while upholding the power of the House to expel its members, reserved to themselves the power to exercise judicial review to judge for themselves the question as to whether the principles of natural justice have been followed by the House before expelling a member. So, principles of natural justice must be given. Without that, if the member is expelled or suspended, then it may go for a judicial review. Thank you.